In the United Kingdom, bigamy, the act of marrying a second person while legally married to a first, remains a criminal offense under the Matrimonial Causes Act 1973, carrying a maximum sentence of 7 years imprisonment. It is also, according to data compiled by the National Office of Statistics and cross-referenced against family court records, significantly more common than most people believe. Between 2015 and 2022, UK family courts processed over 1,400 cases involving undisclosed parallel relationships, arrangements in which one partner maintained 2 or more separate domestic lives, often including children, often including shared finances, often sustained over periods exceeding a decade. In the majority of those cases, the discovery was not made by investigators. It was not made by financial institutions flagging anomalous behavior. It was not made by suspicious friends or vigilant neighbors. It was made by accident. A letter delivered to the wrong address, a name on a school register, a face glimpsed through a window on an ordinary Tuesday afternoon. In the case we are examining today, the discovery was made at a funeral. The widow of a man named Philip, 61 years old, died of a cardiac event on the 3rd of November 2019, was standing at his graveside in a churchyard in Surrey when she noticed a woman she did not recognize, standing at the back of the crowd, holding the hand of a boy who appeared to be approximately 9 or 10 years old. The woman was crying, and the boy had Philip's eyes. Her name was Diane, 58 years old, married to Philip for 31 years. They had 2 adult daughters. They lived in a 4-bedroom detached house on a quiet residential road in Guildford, Surrey. She had, by her own description to family members in the weeks that followed, been entirely happy. She had no reason not to be. Philip had been a senior operations manager for a logistics company. He traveled regularly for work, 2, sometimes 3 nights a week away from home, always with a credible explanation, always with a hotel receipt if one was ever needed. He was attentive when he was home. He remembered birthdays. He knew how she took her coffee. He had, in 31 years of marriage, never once given her a reason to doubt him. He died on a Monday morning in November 2019 of a sudden cardiac arrest, in his car, in a lay-by on the A3 outside Guildford. The coroner recorded the cause of death as natural. There was nothing suspicious about how Philip died. Everything suspicious was about how he had lived. At the funeral, Diane noticed the woman at the back of the crowd during the committal. She assumed, in the way that a person assumes things at a funeral, when they are managing grief and logistics simultaneously, that she was a work colleague, someone Philip had known professionally. She forgot about her. Until 3 days later, when a solicitor's letter arrived at the house. Before we go further, hold this question in your mind. Philip had been living on the same residential road as his wife for 22 of the 31 years of their marriage. The woman at the back of the funeral crowd, the woman with the boy who had Philip's eyes, had been living 4 doors away from Diane for nearly a decade. 4 doors. How do you maintain 2 families on the same street for 9 years without either of them knowing? The answer to that question is this entire case. Stay with me. The solicitor's letter was from a firm in Guildford town centre. It was addressed to Diane by name. It informed her that a woman named Carol had instructed the firm to make contact regarding the estate of Philip, and that Carol wished to discuss the matter of Philip's financial obligations toward herself and her son, now that Philip had died. Diane read the letter twice. Then she called her own solicitor. Her solicitor made initial inquiries. What she found within 48 hours was the following. Carol was 44 years old. She had lived at number 34 on the same road as Diane, who lived at number 58 since 2010. She had a son, now 10 years old, named Marcus. Marcus had been registered at birth with Philip listed as his father. Philip had signed the birth registration. Carol and Philip had not married, but Philip had, according to bank records that would later be disclosed in civil proceedings, been making regular monthly payments to Carol's account since 2009, 1 year before she moved onto the road. He had moved her onto the road. That was the initial theory. A long-term affair, a second family maintained in secret, a man who had kept 2 domestic lives running in parallel through careful financial management and carefully managed deception. That theory was correct as far as it went, but it did not go far enough, because when Diane's solicitor began examining Philip's full financial history and when a forensic accountant was engaged to reconstruct his asset picture, they found something that changed the nature of what Philip had done entirely. He hadn't just maintained two families. He had financed the second one almost entirely using money that legally belonged to the first. The forensic accountant's report, submitted to the family court in February 2020, ran to 94 pages. Its central finding was this. Over a period of 19 years, from approximately 2000, 3 years before Marcus was born, to Philip's death in 2019, Philip had diverted a total of £340,000 from the joint matrimonial finances he shared with Diane into a separate account structure that Diane had no knowledge of and no access to. The mechanism was not dramatic. It was not a single large transfer that might have triggered a notification or a conversation. It was a sustained, calibrated pattern of small diversions, overstated business expenses claimed on the joint account, salary payments routed through a secondary account Diane did not know existed, rental income from a property Philip had purchased in 2004 that was never disclosed to Diane and never appeared in any document she was ever shown. The property, a 2-bedroom flat in Woking, purchased in Philip's sole name using funds drawn from the matrimonial pot, had been rented out for 15 years. The rental income had funded, among other things, the deposit on number 34. The house Carol had lived in, 4 doors away from Diane, had been purchased using Diane's money. But here is the detail that the forensic accountant flagged specifically in her report, the detail that stops you cold when you read it. In 2011, Diane and Philip had remortgaged their home to fund an extension. Philip had handled the remortgage. He had presented Diane with documents to sign. She had signed them without reading them in detail because she trusted him completely. The remortgage had released £85,000 of equity, the stated purpose on the application: home improvement. The extension was built. It cost £43,000. The remaining £42,000 had been transferred, in 7 installments over 14 months, to Carol's account. Diane had signed the documents that paid for her husband's other family to buy furniture, take holidays, and cover the school fees for a child she did not know existed. Diane did not confront Carol immediately. She has described the weeks following the solicitor's letter as a period of what she called a very particular kind of paralysis. I knew and I didn't know at the same time, and some part of me was still trying to find an explanation that wasn't the one that was obviously true. She did, however, start walking past number 34. She had walked past it thousands of times. For 9 years she had walked past it without a second thought. It was a house on her road, a neighbor she knew to nod to, a woman with a quiet child, and a neat front garden. She later told her daughters, once helped Carol carry her shopping in from the car. Philip had been standing at their own front door at the time, watching. He had waved at Carol. Carol had waved back. He had known in that moment exactly what was happening, and he had waved. When Diane finally understood the full geography of what Philip had built, she told her solicitor something that became, in civil court, a frequently cited line from her witness statement. She said, "He didn't keep us apart. He kept us close. I think that was deliberate. I think the proximity was part of how he managed both of us, because neither of us could behave suspiciously without the other potentially seeing." The solicitor underlined that line, because it pointed towards something that changed how the civil case was framed. This was not just a man who had an affair and a secret family. This was a man who had engineered a specific domestic architecture, geographic, financial, psychological, designed to sustain itself indefinitely. He had not expected to die at 61. The civil proceedings between Diane and Carol's respective legal teams and the parallel investigation by Surrey police into the financial conduct proceeded simultaneously through 2020 and into 2021. Surrey Police's Economic Crime Unit opened a file in January 2020 following a referral from Diane's solicitor. The investigating officer, Detective Sergeant Priya Mehta, spent 4 months reconstructing Philip's financial history with the assistance of the forensic accountant and digital forensics specialists from the Regional Organized Crime Unit. What they built was a financial map that covered 19 years, 6 bank accounts, 2 properties, and 1 limited company, a shell company registered at Companies House in 2003 in Philip's name, listed as a management consultancy, which had issued invoices to Philip's employer and received payments that were then distributed at Philip's direction. The company had never filed accounts that reflected its actual activity. It had been dormant on paper, declaring minimal income, paying minimal tax, while actively receiving and distributing funds. HMRC was notified. A separate tax investigation was opened. DS Mehta's investigative report, submitted to the Crown Prosecution Service in June 2020, identified two potential charges: fraud by abuse of position under the Fraud Act 2006, and financial conduct constituting economic abuse under the Domestic Abuse Act 2021, legislation that had been passed in April of that year, and which, for the first time, gave statutory definition to financial abuse within intimate relationships. Philip was dead. He could not be prosecuted. But the investigation had a secondary purpose, one that Diane's legal team had been pushing for from the beginning. Because if Philip's financial conduct could be formally characterized as fraudulent and abusive, it would have direct consequences for how his estate was distributed. It would affect what Carol was entitled to claim, and it would affect what Diane could recover. The CPS declined to bring charges, Philip being deceased, but issued a formal findings letter in August 2020, confirming that the evidence was consistent with sustained financial fraud and economic abuse within the marriage. That letter became the spine of Diane's civil case. The digital forensics component of the investigation produced three specific findings that the civil court heard in detail. First, Philip's mobile phone, recovered from his car following his death and examined under a court order obtained by Diane's legal team, contained a messaging application that was not his primary messaging platform. The application used end-to-end encryption and was not linked to his primary mobile number. It contained a complete message history between Philip and Carol spanning 7 years. The messages showed detailed coordination, logistics, schedules, cover stories, and, significantly, explicit discussions about the financial arrangements between them. In one message, dated March 2016, Philip had written to Carol, "D signed the insurance documents today. Didn't ask anything. I've moved the allocation as discussed." D was Diane. The insurance documents were a life policy whose beneficiary structure had been quietly altered to include Marcus. Second, Philip's work laptop, examined with the cooperation of his former employer, showed that his stated business travel, the 2 and 3 nights a week away from home, had, in approximately 40% of cases over the last 5 years of his life, not corresponded to any client meeting, site visit, or company event in the employer's records. He had been marking himself as traveling for work when he was not. His employer confirmed this in a witness statement. Third, the forensic accountant identified a specific pattern in Philip's expense claims, a pattern she described in court as a substitution mechanism. On nights when Philip claimed overnight accommodation, he claimed hotel costs. Those hotel costs were paid from the joint account. The actual overnight accommodation, in the majority of cases, was at number 34. There was no hotel. The hotel receipts, recovered from Philip's email archive, were from genuine hotels, but the dates did not correspond to the dates claimed. They had been used as cover documentation for nights that had never taken place. He had kept receipts, from real hotels, from other trips, and used them as alibis for nights he had spent 4 doors away from his wife. Here is the question that the civil court did not answer, and that Diane's barrister raised explicitly in her closing submission, knowing it would not be resolved within those proceedings. Carol knew. She had to have known. She knew Philip was married. She knew Diane existed. She had lived 4 doors away from Diane for 9 years. She had, on at least one documented occasion, interacted with Diane directly, the shopping incident, witnessed by Philip himself. The question of what Carol knew, and when she knew it, and what her legal and moral responsibility was for the architecture of deception she had participated in, this question was never fully addressed in the civil proceedings, because the civil proceedings were focused on the estate and the financial claims. Carol's legal team maintained throughout that Carol had believed, for many years, that Philip's marriage to Diane was a long-standing separation, that they lived together for the sake of their daughters, but that the marriage was functionally over. That Philip had told her this, that she had believed him. Diane's barrister put it to the court simply, "A woman who lives 4 doors away from a wife who does not know she exists for 9 years has had 9 years in which to ask herself whether the explanation she has been given is true. The question is not what Philip told her. The question is what she chose to accept." The judge declined to make a finding on Carol's culpability. It was outside the scope of the proceedings. But the question sits in the court record, unanswered. Philip's case, and several others like it that emerged in the same period, contributed to the parliamentary debates surrounding the Domestic Abuse Act 2021 and its provisions on economic abuse. For the first time in English and Welsh law, the Act defined economic abuse as a form of domestic abuse, encompassing behavior that controlled, restricted, or monitored a partner's finances, economic resources, or economic autonomy. Campaigners from Surviving Economic Abuse, a UK charity that had been lobbying for this change for several years, cited cases like Phillips as representative of a category of financial harm that the law had previously failed to name. A spouse who is deceived about the family finances, who signs documents without understanding their true purpose, who loses access to equity they did not know was being diverted. That spouse, under the old framework, had limited legal recourse beyond civil dispute. Under the new framework, the conduct is named. It is abuse. Philip died before the act came into force. His estate was subject to the civil proceedings that concluded in late 2021. Diane received the primary share of the estate. Carol received a financial provision for Marcus's maintenance as Philip's biological son. The Woking flat, purchased with matrimonial funds, generating rental income for 15 years that Philip never disclosed, was sold. The proceeds went into the estate. Carol moved out of number 34 in January 2022. Diane still lives at number 58. Diane has given 2 interviews since the civil proceedings concluded. She has been careful and precise in both of them. The manner, people who know her say, of a woman who spent 31 years married to someone who was careful and precise about everything. In the first interview, she said, "The hardest thing is not the money. I'm not going to pretend the money doesn't matter, because £340,000 is not nothing. But the hardest thing is the recalibration. Every memory, every holiday, every Sunday morning, every time I thought he was somewhere, and he wasn't. You have to go back through 31 years and understand that you were living in a construction. And the construction was very good. He was very good at it." She paused. Then she said, "I think about the shopping. I think about standing there helping her with her bags, and him watching from the door. I think about what he must have felt in that moment, whether it was fear or satisfaction or something else entirely. I don't know. I'll never know. And that not knowing is permanent now. I can't ask him." Her daughters, both in their late 20s, both of whom had known Philip as a devoted, present, reliable father, have not spoken publicly. They declined to be contacted for this video. Marcus, Philip's son with Carol, is now 14. He is too young to have understood everything. He will, in time, understand all of it. The civil proceedings produced one further disclosure that had not been anticipated by either legal team. In reviewing Philip's complete digital archive, DS Mehta's team had identified a folder on his personal cloud storage containing scanned documents. Among those documents was a handwritten letter, undated, never sent, addressed to no one, that Philip appeared to have written sometime in the mid-2010s. The letter was disclosed to both legal teams as part of the discovery process. Its contents were read into the court record. In the letter, Philip wrote, and I want to be careful here, because the language matters, and because this is a real document from a real person, that he had not intended for things to become what they became, and that he had tried on many occasions to find a way to change the situation, but had always found reasons why the moment was not right. He wrote, "I have told myself for years that I would know when to act. I have not acted. I think now that I never will. I think the truth is that I will die before this resolves itself, and that the resolution will be someone else's problem. I am sorry for that. I don't know who I'm sorry to." The letter was never sent. He died 4 years later, in a lay-by on the A3, of a cardiac arrest. The resolution was, as he had written, someone else's problem. It became Diane's problem, and Carol's, and Marcus's, and the 2 daughters who will carry this for the rest of their lives. There was one element of the civil proceedings that produced a result nobody in Diane's legal team had expected. Philip's life insurance policy, the one whose beneficiary structure he had quietly altered in 2016, adding Marcus as a secondary beneficiary, had been taken out in 2001, 18 years before his death. The policy's primary beneficiary was Diane. The secondary beneficiary, added in the 2016 alteration, was Marcus. The insurance company, on reviewing the claim, initially indicated they would pay out to both beneficiaries in line with the policy structure. Diane's legal team challenged this, arguing that the 2016 alteration had been made without Diane's knowledge or consent, and that the funds used to pay the premium since 2001 had come from the joint matrimonial account, making it, in effect, a joint matrimonial asset that had been unilaterally restructured. The insurance company's legal team reviewed the policy documents. They found that the 2016 alteration form had been completed with a digital signature, a signature that the digital forensics team confirmed matched Philip's own device and login credentials. But it had also been witnessed. The witness signature on the 2016 beneficiary alteration form was Carol's. She had witnessed a document that changed the financial benefit Philip's death would provide in favor of her own son, without Diane knowing the document existed. The insurance company paid out to Diane only, pending the family court determination. The family court, in its final order, made provision for Marcus from the estate. But Carol had signed that form. She had sat in a room with Philip, with a document that restructured his wife's financial future, and she had put her name to it as a witness. That, more than anything else in the case, is what Diane said she could not move past. The civil proceedings concluded on the 18th of October 2021 at Guildford County Court. The judge's summary ran to 41 pages. The key findings were these. Philip had engaged in sustained financial deception within his marriage over a period of not less than 19 years. The total value of matrimonial assets, diverted without Diane's knowledge or consent, was confirmed at £340,000. The shell company had been used as a mechanism for undeclared income, and HMRC's separate investigation had identified unpaid tax liability of £67,000, which was recovered from the estate. The Woking flat was deemed a matrimonial asset despite being held in Philip's sole name, as the purchase funds were matrimonial in origin. Diane received the matrimonial home outright, the primary share of the estate, and a compensatory uplift in recognition of the undisclosed financial conduct. Carol received a maintenance provision for Marcus, structured as a periodic payment until Marcus reached the age of 18. She received nothing further. Number 34, the house on the same road, had been rented, not owned by Carol. Philip had paid the rent. When Philip died, the rent stopped. Carol had been given notice to quit by the landlord in early 2020. She was gone by January 2022. In her final witness statement, Diane said, "I have been asked whether I am angry. I am. But anger is not the primary thing. The primary thing is that I spent 31 years building a life with someone who was, the entire time, building something else as well. And the thing he was building was 4 doors away. I walked past it every day, every single day." She paused in her statement, and the transcript notes this, a pause of approximately 12 seconds. Then she wrote, "I want to be very clear about one thing. I am not a fool. I was deceived by someone who was very good at deceiving people. Those are not the same thing. I need that to be understood." Philip's case contains several documented patterns that financial abuse specialists and family law practitioners now cite in professional training contexts. First, undisclosed secondary accounts. Philip maintained bank accounts that Diane had no knowledge of. UK law does not require both spouses to have access to all accounts, but it does require full financial disclosure in divorce proceedings. If you are going through a separation and you suspect your partner has accounts or assets you are unaware of, you have the legal right, under the family procedure rules, to request full financial disclosure. A court can order disclosure if it is not provided voluntarily. Second, the shell company mechanism. Philip used a limited company registered in his sole name to receive and distribute income that should have been declared as part of the matrimonial finances. Companies' house records are publicly available. If you are concerned about undisclosed business interests held by a partner, those records can be searched by name. Third, document signing under deception. Diane signed documents, including the remortgage release and the life insurance policy, without fully understanding their purpose or consequences, because she trusted Philip to manage their finances. Family law specialists advise that both partners should independently review any financial document before signing, particularly remortgages, insurance policy alterations, or pension beneficiary changes. Fourth, the proximity strategy. Philip's decision to house Carol 4 doors away from Diane was not incidental. Forensic psychologists who have reviewed this case describe it as a documented feature of controlling behavior, maintaining geographic proximity between two relationships as a mechanism of control over both parties. reducing the risk of independent investigation by either. If you have concerns about financial abuse within your relationship, the Surviving Economic Abuse Helpline can be reached at 0808-196-8845. There is a concept in family law and forensic psychology that practitioners call the competent deceiver, a category of individual whose deception is not characterized by recklessness or impulsivity, but by sustained, systematic, architecturally sophisticated dishonesty that specifically targets and exploits the trust of those closest to them. Philip was a competent deceiver. He was competent for 31 years. The research on this profile, and there is substantial academic literature, including work from the University of Huddersfield's Applied Criminology Department, suggests that competent deceivers share several consistent characteristics. They are highly organized, they compartmentalize effectively, they are skilled at emotional attunement, knowing precisely what each person in their life needs to hear, and they operate most successfully within relationships where their targets have the highest degree of trust and the lowest degree of financial independence or oversight. Diane trusted Philip to manage their finances. Not because she was passive or unintelligent, she was neither, but because that had been the structure of their marriage, established early and never questioned, because there had never been a reason to question it. That structure, one partner managing the finances while the other trusts without verifying, is the single most common precondition identified in cases of long-term financial abuse within marriage. The lesson is not distrust. The lesson is shared visibility. Both partners should have direct access to all joint accounts. Both partners should receive bank statements. Both partners should be present, or at minimum independently advised when financial documents are signed. 31 years. £340,000, a house 4 doors away. None of it required a single act of dramatic deception. It required thousands of small ones, sustained by a single structural condition, one person who managed everything, and one person who trusted them to. Philip is buried in a churchyard in Surrey. His grave is maintained. His daughters visit it, separately, at times of their choosing. Whether Diane visits it is not something she has discussed publicly. Carol did not attend the civil proceedings in person. She was represented throughout by her solicitor. She has not spoken publicly about the case. She moved to a different part of Surrey after leaving number 34. Her whereabouts are not public knowledge. Marcus is 14. He goes to school. He plays football, according to a detail in Carol's family court statement that was not contested. He has never been named in any published report. He is a child. He will one day be an adult who has to make sense of all of this. The HMRC investigation recovered £67,000 in unpaid tax. That money went to the government. The Domestic Abuse Act 2021, which, for the first time, gave statutory recognition to economic abuse, has now been in force for 3 years. Surviving Economic Abuse reported a significant increase in calls to their helpline following its passage. The legal framework now exists. The awareness is growing. But here is what stays with me about this case. Philip wrote a letter in the mid-2010s in which he acknowledged, in plain language, that he would never resolve what he had created, that he would die before it was resolved, that the resolution would be someone else's problem. He was right. He was right about all of it. And somewhere in the United Kingdom, right now, there is another Philip. Not identical, the specifics are always different, but the structure is the same. The compartments are the same. The carefully managed proximity, the signed documents, the plausible explanation for every absence. And somewhere, there is another Diane, walking past a house on her own road, not knowing what's inside it. The hardest thing about this case, the thing that makes it genuinely difficult to put down, is not the scale of what Philip did. It is the precision of it, the patience of it, the fact that it worked completely for 31 years. It only stopped working because his heart did.